if it's an executive function issue or if Dad's just trying to cause problems. But in the session on September 13th, 2024,
Your Honor, this has the extremely high burden to prove that, one, there has been a substantial change in circumstances affecting the welfare of, and two, that modification serves the best interest. It is clear and unequivocal that Ms. has not met that burden. This court has noted that both parents do not co-parent well. We have proved to this court by clear and convincing evidence that she is as much to blame for the conflict as she has no respect for her. She routinely and repeatedly insults and belittles when he does not blindly agree to her demands or do things the way that she wants them done. She blames everything and then either tells fault or demands that positive light to cover up her failures against. She unilaterally makes decisions for and then accountable or punishes him even when they're directly in contravention of this court's clear orders, when he does not comply with her demands. She fails to follow this court's orders. By her own admission today, she decides what order she follows. She decides solely what is in her best interest. She forces non-medically necessary treatments that have caused stress or pain, or does not take actual illnesses seriously, which has caused illness to become more severe than it otherwise would have to be. In fact, she admitted today that she was wrong several times. And if it weren't for insistence in seeking medical attention for things would have been substantially worse. He has an extremely well-bonded relationship with his father. He trusts in his best interest. Never abused. CPS has never been contacted against him. Been arrested for domestic violence or child abuse. Loves beyond compare. We proved to you and provided evidence to the court about the things that he supports his education. He teaches him new things. He encourages to think outside the box. He encourages to solve conflict with his peers and learn how to become an upstanding and successful human being. What Mr. is asking is to cut out of his life, to remove that positive influence, to remove that nuclear parent from. Nothing could be more detrimental to a child. Nothing. And Your Honor is well aware that the science bears out that a child that has two parents in their life is more successful, usually does better in high school, usually goes on to college, usually gets a degree, usually marries and has a family, is successful in their career. What they're asking you to do is to remove and take away almost the most constant figure in his life, the most steadfast, the most secure, the most mentally competent person in his life. Again, Your Honor, we proved beyond a shadow of a doubt that he is an active, engaged, and devoted father to his son. He is capable, willing, and has repeatedly demonstrated he will go above and beyond to support his best interest in his success, often to his own detriment, often to his own success because he's trying to help his son be successful. Coincidentally, his parents, Mr. And Mrs. Encourage, they support, and as a family, Mr. testified that they, as a family, are encouraging and supportive of this behavior. they together as a family will continue to do everything they can to make sure that successful and are willing to compensate and pay that. Your Honor, this court simply cannot trust that if vested with primary physical custody or sole legal custody, that facilitate and foster with both parties have good qualities, and those qualities should be shared with, which will enable him to be a well-rounded, successful human being. But Your Honor, you have heard testimony today that, again, Ms. unilaterally decides whether she will follow court orders, and unilaterally decides and is the sole arbiter of what is in her best interest. She claims that she, constantly tries to communicate with, that she constantly tries to, get him to facilitate things. But again, the evidence shows that she unilaterally decides what's going to happen. She unilaterally decides how things are going to go. She yells at him when things don't go her way. She belittles him. She denigrates him. She degrades him. He does not do those things to her. She does not foster and support a co-parenting relationship. Again, I would remind this court that everything that Ms. has accused of, she does also, or is the primary perpetrator of it. Again, the law is clear on this point, Your Honor. By and large, we're a joint physical custody state. And at the end of the day, what they're asking you to do is go against the law. To go against the wishes and to go against the clear mandate of the legislature. Again, you cannot punish a father for being actively engaged, for being extremely concerned about his son's safety, success, health, and well-being. That's what they're asking you to do. Again, Your Honor, it is in this child's best interest to maintain joint physical custody and to maintain joint legal custody. Thank you.
Have any brief rebuttals?
No, thank you, Your Honor.
Okay, so we're going to take our lunch break now. I think my findings are going to be pretty long, so I don't know that it's going to make a difference if we come back at 1 or come back at 1:30. So do you guys have a preference? I'm open to.
Whatever the court's pleasure.
Yeah, whatever you
I'm going to take the 1:30 because make sure I have time to review things and have everything out. Then you guys can leave what you need to here. The doors will be locked.
Thank you, Judge.
Does the court need can we take the exhibit binders?
You can take them, yeah, if you want to take them over to the other, do that. Yes, I don't need any of them.
Thank you.
And you have, Joe, you have the double, AAA. Thanks. Back on the record, in reviewing my notes, I think there's 2 evidence issues I wanted to bring up, or evidence that I don't have. Dr. Smith's records appear to be missing a big chunk of the sessions in 2024, because the notes only indicate 4 sessions in September through the end of the year. So it's like missing January. So I did look at my notes, and Dr. Smith did testify that 11 appointments in 2024. Mom took 7, Dad 4, and then 2025 he's had 1, at least as the time he testified, and then Mom took that. So Dad does owe her money, and she's gonna have to upload the receipts, maybe upload them again on that, but there is definitely a difference in that. But she's got to have receipts that she paid them in order for that to be uploaded. Second, I heard what Mom testified to regarding the medical insurance. So that leads me to a piece I don't have. His dad has the Health Plan of Nevada HMO plan, and he, on page 4 of his FDF, said that's $263.52 but that includes him and the child. Does he have the ability to get a breakdown?
He believes that he can. Apparently, you have to talk to an actual human being to be able to do that, but
Well,
the probability is yes.
I know HPN sends you, when you're private insured, monthly invoices that should have a breakdown between subscriber and dependent.
To you,
It's
can you
only
pull it up
two.
online?
I can try to check an invoice.
Yeah, see if you can pull it up
Yeah, you can
online.
pull that, you don't have to do it right this second, but I will need that.
He's gonna try to log into his computer and see if he can do it.
Okay, I'm gonna need that for the calculation on the child support when we get there. All right. So. The court finds that the parties are parents to one minor child. He's currently 9 years old. Both parents and the minor child, excuse me, continue to live in Nevada, and this court has continuing exclusive jurisdiction under the Uniform Child Custody Jurisdiction and Enforcement Act. The last custody order is the findings of fact, conclusions of law, and decree of custody that was entered on September 7th, 2021. The parties have joint legal and joint physical custody after a trial 4 years ago in May of 2021. There have been some orders, I'm going to go over the relevant procedural history as well, some orders clarifying things after that, but that is the last long-term custody order that they have. Since September 7th, 2021, parties have engaged in significant post-decree litigation, mostly about legal custody issues. Specifically, on October, this is my binder of the orders in this case. It does include the Supreme Court orders too, but that's a binder of orders in this case, starting from the decree of custody. On October 13th, 2021, the court held a hearing on a long list of disputes between the parties, including but not limited to resolving issues related to the PC coordinator's decisions, payment of her fees, request to issue order show cause against dad for alleged violations of legal custody orders, and mom's request to order dad to administer the eye drops prescribed to their son. Dad also requested to be granted sole decision-making authority over medical decisions for their son. The order from that hearing was entered on November 1st, 2021. This order also includes a very detailed communication protocol for these high conflict parents that came from the work of the PC coordinator. One of the other disputes that were resolved by the court at the hearing on October 13, 2021 was dad's refusal to sign the application for passport, despite the PC coordinator already making a determination that both parents should cooperate in order to get a passport issued for him. The court had to grant mom sole authority to get that passport, and that was set forth in a separate order entered on November 1st, 2021. There was no good reason for dad to refuse to consent to the passport, so the court had to conclude that he did that as an attempt to assert power and control over mom, and mom was awarded attorney's fees for that. When mom wanted to take on a European vacation during the summer, her summer break custodial time in 2022, dad refused to sign the requested travel letter so that mom was confident she could purchase the expensive travel arrangements. Mom had to file a motion for this relief, and the court also addressed dad's concern about knowing the exact details of mom's travel with their son by clarifying a mutual order requiring them each to provide detailed itineraries at least 2 weeks before travel. Dad's actions in that instance were passive-aggressive and designed to frustrate and/or control mom. And the order on that hearing was entered on May 25th, 2022. The court had to clarify the terms regarding each parent's summer vacation time immediately after entry of the decree of custody because dad decided to take 3 extra days of mom's time. Mom was granted makeup time in the summer of 2022, and that's in the order entered on October 20th, 2021. The court also had to enter a much more specific standalone order regarding holidays and the summer vacations. That order was entered on September 20th, 2021. That's still in effect today. On September 12th, 2022, the court conducted a hearing on both parents' requests for an order show cause against the other parent for alleged violations of orders. At that hearing, the court also resolved issues related to the right of each parent to take out of state on their own custodial time, issues regarding dental care, and in order that mom could choose the dentist and dad could choose the dermatologist. This is a highly unusual level of detail that the court must order regarding legal authority issues, and that order was entered on September 26, 2022. On February 21st, 2023, the court conducted an evidentiary hearing regarding respective allegations of contempt. The findings of fact inclusion of law from that hearing was entered on April 14th, 2023. At the evidentiary hearing, the parents raised issues regarding need for attend counseling, which they could not resolve themselves. The court had to enter a separate order to resolve that issue so that no therapist again. And that order was entered on March 14th, 2023. In 2023, despite the order entered regarding mom's summer travel with 22, dad again refused to sign a travel letter for her to take on her summer break time so that she would feel comfortable spending the money to purchase the travel arrangements. Dad had no legitimate reason to refuse to sign the letter, especially in light of the order from 2022, yet he chose to play a game of power and control with mom again. Therefore, the court entered a standing order allowing either party to travel outside the country with on their custodial time in order to stop dad from playing this game again and forcing mom to incur more attorney's fees when he had no legitimate basis to refuse mom's request. That order was entered on May 18th, 2023. On November 4th, 2024, the court had to enter an ex parte order allowing a Disneyland field trip that happened on mom's custodial time. Dad was served with that motion, and the exhibits attached to it shows that there was communication from mom to dad on our family wizard regarding that, and the court waited sufficient time for dad to oppose her request and explain why he was opposed to that field trip with his GATE classmates. Filed a timely opposition, and that order was entered on November 4th, 2024. Sometimes dad does not say no to mom's requests or suggestions. Instead, he just plays a passive-aggressive game of failing to respond to mom in a timely fashion, which then leaves mom to decide if the issue is worth filing a motion over and incurring attorney's fees, or if you just miss out on it. The court has had to enter, with regard to the orders, the court has had to enter post-decree. Most of the time, dad does not even have a legitimate opposition to what mom is asking for. It appears he fails to respond to mom in a timely fashion just to annoy and vex her, but it is suffered from either mom not having the money to do extra things for him because she spent it on attorney's fees, or he just does not get to do something like basketball or soccer for 2 seasons that he could have played with his friends. That is not fair to. Also, there has been delays in medical treatment and therapy because of these parties' inability to make basic agreements. That is not in his interest. This court's post-decree orders have been about resolving disputes between the parents, but also, in this case, making the most specific orders possible in order to reduce points where the parents can be in conflict. But it has not been enough to reduce the conflict sufficiently in this case. The standard on mom's motions to modify the legal and physical custody is found in the Romano case. Mom has to show that there's been a material change in circumstances affecting the well-being of the minor child since September 7th, 2021. Dad argues that these are the same issues as before September 7th, 2021, and that there's been no material change. In one way, he's right. The problems in parents co-parenting have not changed a lot, and that is the problem. It is not unusual for parents to struggle with communication and co-parenting immediately after the separation and until that initial custody order is entered. For most families, things then usually improve once there's clear orders in place. In this case, even after being told that his actions are not in the best interest of and being sanctioned attorney's fees owed to mom, Dad's failed to change how he communicates or interacts with mom. The failure to improve his communication and co-parenting when he's had explanations and 4 years to do so is a material change in circumstances. Additionally, Dad has not shown a willingness to change or improve. As Dr. Smith said, there's just things that he will not co-parent with her on and would prefer to parallel parent, which is not always going to be in his interest on things such as medical care and extracurricular activities. They can't be each doing their own thing on their custodial time on some of those things. Mom's also stuck in a dysfunctional communication pattern with Dad. There's a better situation regarding the communication and co-parenting. Therefore, the court finds that mom has established a material change in circumstances that is negatively impacting, and then the court looks at the best interest factors. As to those factors, the legislature provided a non-exhaustive list of factors for the court to consider in NRS 125C 035 subsection 4. As to those factors, the court finds they're going to factor A, wishes of the child if they're of sufficient age and capacity to form an intelligent preference. Neither parties argued that old enough or mature enough to form and communicate an intelligent preference. Also, neither party presented any evidence regarding a preference. Therefore, the court finds that factor is not applicable. Factor B, nomination by parent or guardian, is also not applicable in this case. Factor C, which parent is more likely to allow fruitkin associations a continuing relationship with the other parent. In this case, there's no evidence that either parent has withheld the child since the summer of 2021 issues, which you typically see in a case of a parent interfering with the other parent's relationship. That's not happening in this case, or at least there's no evidence presented that that's happening. Neither parent is as supportive of the other parent's relationship as they could be, but it seems to be related to their different parenting styles and different priorities. They still have the same concern, the court has the same concerns regarding both parents' willingness to support relationship with each parent. The court finds that this factor does not favor either parent. Factor D, level of conflict between the parents. This is still very high, 4 years post-decree in this case, or 4 years post the custody trial. Both parents contribute to the conflict. They each have very different communication styles, but suffering from things such as being triangulated between his parents and having loyalty conflicts and delays for him to have services or activities that would benefit him. This factor favors the court trying more ways to reduce points of conflict between the parties, including maybe sole legal custody. Factor E, ability of the parents to cooperate to meet the needs of the child. These parties have in some instances, they've been able to do things like switch weekends or cover for each other when there's been a conflict, or take him to something. So it's not 100% that they can't. There's just not a lot of it, and that's the problem in this case. Again, is suffering because his parents cannot work together for his benefit. There has been a delay or denial of things he needs or wants due to this problem. As I said, both parents contribute to the problem, and this factor supports awarding one parent sole legal custody. The question the court has is which parent is going to do a better job of that. The evidence shows that mom is more organized and gets things done in a timely fashion. Dad does not seem to be a planner. Even looking at the example in 2021 of the school choice. Dad was given extra time because he didn't have a backup plan at the trial in May of 2021 of where his own opinion about where he had school here in Nevada. The court gave him extra time to brief that. He did provide a brief, and the court made a ruling on that decision. After that, he tried to get hold in Foothill Montessori, and 2 months after the court already made that decision, and did that without even discussing it with Mom, how that would be an option for him. It's just that he's not timely. He's not timely in responding to Mom. And some of these issues of him delaying in communication or not making clear communication or not making decisions in a timely fashion may not be issues that he has directly with Mom or the purpose, but he does have a diagnosis of ADHD and depression, both of which can affect a person's executive functioning and issues of just not being able to focus on something that needs a decision on. The court finds that this factor favors awarding Mom sole legal custody. Factor F, mental and physical health of the parents. There's no evidence that either parent has any chronic medical issues that impact their parenting or co-parenting. Both parents have been diagnosed with mental health issues, and both take medicines for their diagnoses. And their mental health issues do impact their ability to communicate effectively and to co-parent with each other. The court finds that this factor is equal with both parents and does not favor either parent. Factor G, the physical, developmental, and emotional needs of the child. Almost 10 now. He appears to be a very bright child and much more aware of the nature of conflict between his parents than he was when he was 6 years old. He needs to be protected from parental conflict as much as possible, but he also needs to have decisions not be delayed due to the inability of the parents to agree on something. This favors delegation of authorization on some issues to one parent and reducing the amount of conflict between the parents. Per Dr. Smith's records, struggled a lot with having two homes and parents who have very different expectations. That seemed to be more of a problem in 2023, according to records, but it's a theme throughout that. Dr. Smith worked with him and the parents about his feelings about this, and the court does not believe that that means that he needs one home or to have and have the other parent excluded from his life. It does mean that he does need less conflict, and he does have a continued need for counseling to work on his ability to express his feelings and work through them. Dad needs to make that a priority for well, or Mom needs to be in charge of the counseling appointments. Factor H, the nature of the child's relationship with each parent. There's no credible or current evidence that have a good relationship with both parents. This factor does not favor either parent. The factors I, ability of the child to maintain a relationship with a sibling. Factor J, history of abuse or neglect of the child. And factor K, engage in active domestic violence against parent or any other person since entry of the decree of custody. That's not applicable. And L, also engage in active abduction, is also not applicable. Under the catch-all category of other things, like I said, Dr. Smith indicated that Dad's not willing to co-parent with Mom on several issues, and he would prefer to parallel parent. To do that and not have this out on things, the court needs to delegate final decision-making to one parent on some issues in this case. As to Dr. Monique, the court finds that, first of all, the information she had was not very helpful due to the limited interactions she had with her 3 years ago. But there was a showing of bias and the court has concerns about her credibility. But I said, mostly her information was so dated, it didn't help the court with the decisions it needs to make at this time. Another example, Dr. Smith's records of, I don't know if it's an executive function issue or if Dad's just trying to cause problems, but in the session on September 13th, 2024, and both parents testified about that soccer practice that Dad was supposed to pick up, and that because he didn't, there is really no excuse, and Dr. Smith explained that to Dad as well. There's no excuse why he didn't have the address where he's supposed to pick up his son. He's in charge of getting that information, and he was provided the same information all parents were provided. And to wait to the last minute and ask Mom to do that while she's the one took him to that was not reasonable and just indicative of all of the problems in this case. But that was unnecessary emotional problems for. Based upon the best interest factors, the court makes the following orders. As far as, I said, legal custody, dictates delegation of some sole legal authority decision-making. First of all, both parents are going to continue to have information and be required to share information regarding. So what I'm going to incorporate in the definition of joint legal custody is going to be from the following from the decree of custody starting on page 11. Under line 19, it talks about joint legal custody being defined as follows. So paragraph A will be eliminated. Paragraph B will remain in. Paragraph C, D, and E will remain in. Paragraph F is going to be eliminated. Paragraph G will remain in. Paragraph H will be eliminated. I is going to be modified. That's about encourage liberal communication. I'm going to modify, I'm going to leave in the first sentence of paragraph I. I'm going to eliminate the rest of that paragraph because I'm going to make different orders today regarding FaceTime and video calls. Paragraph J and K will remain in. So basically the information sharing will remain the same. Both parents are entitled to have access to their medical records, school records, consult with professionals. All of that will remain the same. As far as medical, and my order regarding our family wizard will remain the same. These parents need to, for many reasons, stop texting each other stuff that should be in our family wizard, but they need to also look at our in a timely fashion and respond to requests that need to be responded to. So text messaging, because I believe, and the text messages seem to confirm my belief that I ordered a text and seatbelt rule in this case when the parents have to pick up one to another. So texting that they're here so the child can be sent out for the child exchange, that's appropriate. Texting I'm running 5 minutes late for a child custody exchange because of the traffic, that's an acceptable use of text messaging. I think he broke his arm, I'm taking him to the urgent care, this urgent care. That's a text message appropriate thing. But a lot of the communications, I think I counted that there is over 1,100 pages between our family wizard and text messages for the last 4 years. With regard to medical, Mom will make sole decisions regarding changes of providers and making appointments, but shall keep Dad informed via our family wizard. And Dad has the right to information from the appointments if he doesn't attend, or to attend the appointments. For example, typical pediatrician's office, when you do the yearly well check, they will provide you with a handout that says things to watch out for, things that they should be doing developmentally. That kind of handout, if Dad didn't attend that appointment, would be appropriate for Mom to upload and copy to him on our family wizard. But mom will make the final decisions regarding treatment unless dad wants to file a motion and handle that. Both parents will also be required to follow the directions from the providers, for example, as the eye drops. With regard to sports and extracurriculars, his best interest dictates the needs of parent to have sole legal decision-making authority on this, and mom will have that so that there's no delay or denial of have that kind of thing. That will be, again, mom will do that. Mom shall try not to schedule activities on dad's custodial time without his prior written consent. But sometimes that's not going to be in mom's control, as we saw with the soccer practice and soccer games, because they're going to continue to alternate weekends, and those games are on the weekends. Mom must keep dad informed on our family wizard, and dad must take practices and games because of the benefits for him, with rare exceptions such as some kind of communicable disease or sickness or a special occasion that conflicts with it. So it generally should be if the coach sets practices on dad's custodial day, dad's going to have to take him or arrange to let mom take him, which they did some of that too. Also for paying for extracurricular activities. Mom is going to pay 100% of that, and that will be considered the cost of that will be considered when I calculate child support.
Ronna, before you move on, so there's no confusion, you said dad, all practices and games, you didn't clarify during his custodial time?
Right, during his custodial time, yes,
Okay,
sorry.
thank you.
I didn't say that. Yes, during his custodial time, it may have to happen, but mom is going to try, as she did with the soccer, to get it to where it's not on his unless he commits to that too. Again, it's not about either of these parents, it's about his having a benefit. Also, you both have a child that is the only child in the home, so his ability to socialize, do sports, group sports, and those kind of things, and learn the skills that you learn from that is beneficial to him. But there is a reasonable happy medium also in terms of the number of activities and the commitment to it. He can't be every evening during the school week in an activity, and then he can't do his homework, especially as schoolwork's going to start to get harder for him as he gets into middle school. So on school activities, each parent can consent to the activities that occur on their custodial time without the other parent's consent. So the court's going to incorporate the standing terms that were put in the November 4th, 2024 order on that. With regard to school, the court understands that the parents are probably going to have more litigation if one of them is not given sole legal custody over this issue. But this issue is very important to the future. So the court is not going to cut dad out of input on this decision. Due to the timing of where we are in the current school year and how things work to get a child into a different school, we're going to have to attend Ellis Elementary School for 5th grade, which is the 25-26 school year, unless a miracle happens and the parents mutually agree to a different school than that. It's just very late. I can't get an evidentiary hearing in time before August 11th to make a resolution of their dispute, if there is one. And when I say if there is one, I mean as the school options. As I did say, and Mom was absolutely right, in fact, she's the one who brought it up, and I denied her motion and clarified on schooling. With regard to plaintiff's motion for an order show cause against defendant for trying to enroll their son in Foothills Montessori and for refusal to sign on the passport, it's about the A1 affidavit. The bigger problem is that there is no order saying that a parent cannot apply for as many schools that they want to spend the time and money on. Private schools seem to cost money to apply to. It is a change in schooling that would have to be agreed upon by the parents or ordered by the court after an evidentiary hearing. So if defendant wants to spend money applying to and getting other options and presenting other options to plaintiff, the court does not find that contemptuous. So Ronald's right that both parties have the right to do that. Dad could have applied, and he knew that. That was way back on the hearing. Let me see. Which order is that in? That's from the order from November 1st, 2021. So both of them have had that ability to do that. For example, if they want to apply for magnet schools, private schools, or get him into a charter school, they both have to have the ability to put him on the list or make the applications or something in order to get that option. He only has currently, for 5th grade, the option of Ellis because he hasn't been admitted to any other schools. Then again, that's a non-issue, but like I said, I don't have time before the school year to resolve a dispute on that. But for middle school decision, each parent needs to secure their options for the 2026-2027 school year for 6th grade as soon as possible. The only ruling the court has made about schooling that would still apply at this time is that homeschool is not possible for these parents to do. Dad can propose private school, whether it's religious or not, a magnet school, a charter school, or public school, and mom can propose what she wants as well. But both of them, like I said, have to try to secure those spots. So I know that, I think the school district moved back applications for magnet schools to like November. So it would be November this year, you would have to apply for him to be admitted next year to a magnet program. And they have a lot of middle school magnet programs. So that could be one option. And each parent can present more than one option to the court if it's there. Court understands that the parents probably will not agree, but they should explain to each other in our family wizard the reasons for their choice, their number one choice, and then a number two choice if they want to. And someone needs to file a motion by no later than March 1st, 2026, so the court can set an evidentiary hearing in time. If dad proposes a private school for middle school, he has to have an enforceable written commitment to be able to pay for 3 years, because it's not fair to start middle school at one school and have to change it only due to these parents don't have the ability to pay for private school long term. The standing order regarding passports and travel will continue and be incorporated into this order. Mutual behavior order will stand and be incorporated into this order. With regard to FaceTime or phone calls, this is another area for conflict between these parents. Older now and does not need as much of these calls to maintain his relationship with the parents. Also, now that he's older, he has more activities that go later in the evenings, and he has a later bedtime. So the court is going to, I thought about just eliminating the call schedule, but that might cause conflicts too. So I'm going to reduce it to just Tuesdays and Saturdays between 8:30 and 9 p.m. where he is. The non-custodial parent will continue to make those calls, and both parents will limit distractions like video games or watching other programs, YouTube, whatever they watch these days. And the parents can change the times or days if it interferes with an activity that he's doing. Because you don't want the calls to be a chore to him. And if you interrupt something he's doing, like soccer practice or something, to do a call, he's probably not going to be happy about it and not that engaged in it. The court finds that both parents would benefit from individual counseling to work on their own individual issues, in addition to that they're both continuing their treatment with medications. But the court finds that counseling really doesn't work if it's court-ordered and the parties don't buy in. So the court's going to suggest that for both parents have the best mental health, that they do some individual counseling. And I think that was recommended by one or both of the counselors. The court is also going to order that each parent take parenting classes. There are free parenting classes through Clark County Parenting Project, and you have to take the triple P positive parenting for the age your son is in. And I'm gonna order, Dad will take the next class that is open after his summer break time, because I don't want to, he will still have that block of time to go visit family or travel or whatever. And then Mom will take the next one after that. So I don't want it to interfere with either parents' travel plans for summer, but I would like them to do that and file proof that they've done that. Also needs regular, consistent counseling as recommended by Dr. Smith. I said both parents need to make it a priority, but if Dad's not scheduling one time a month on his time, then Mom can schedule the both appointments in the month. And have one-on-one with Dr. Smith, with either parent who brings, as Dr. Smith recommends. They will continue to equally divide the cost of counseling. And as I said, Dad owes money to Mom. I think she's right about the 300, but she's gotta have the receipts and resend them, and Dad will have 30 days after she resends them in our family wizard to reimburse her. And because there hasn't been an equal taking of counseling, they're both gonna have to upload those expenses in our family wizard and do the 30-30 rule and split those. The holiday and vacation orders is going to remain the same as set forth in the September 20th, 2021 standalone order, and that will be attached as an exhibit to this order for clarity. With regard to physical custody, the court finds that the evidence does not indicate that a change in physical custody designation is in his best interest, but a change to the joint physical custody schedule is in his best interest. First of all, because of transportation to school issues, and second, because Mom is going to have to do more of the appointments and extracurricular activities on her time than Dad. So Mom's motion for primary physical custody will be denied, but we're going to institute a new custodial schedule as follows. Calendar. So who has Memorial Day weekend this year?
Is it this weekend?
Huh?
It's this weekend.
It's this weekend, yeah. Who has this? So that I can make it clear when we're switching. I don't remember off the top of my head.
So you have in this regard?
Mr. This weekend, Your Honor.
Okay, so what we're gonna do is Mom's custodial time each week is going to be from Sunday at 8 p.m. to Thursday drop off at school, or Wednesday at 8 p.m. if he's not in school on Thursday. Mom will pick up from Dad on Sundays using the text and seatbelt rule. Dad will have, his custodial time will count as Thursday start of school, and, or 8 p.m. on Wednesday if school is not in session on Thursday. That would be the beginning of his weekly custodial time. Dad will pick up from school to start his, or from Mom using the text and seatbelt rule if it's Wednesday at 8 p.m. And then weekends will be divided, defined as, Dad's custodial time will end on Friday after school or 3 p.m. Mom will pick up from Dad on Fridays if there's no school and it's her weekend. Otherwise, Dad will pick up at school, or Dad will keep him if it's his weekend. It will just flow into his weekend. They're going to alternate weekends, which will be defined as after school on Friday or 3 p.m. on Friday if there's no school, to 8 p.m. on Sundays. And then Mom is going to have the weekend that starts on Friday, May 30th at 3 p.m. He won't be in school. Now, this is the normal schedule. So, and I said I don't have your holiday and vacation schedule memorized. That still takes precedence. Holidays and the scheduled vacation time take precedence over the normal custodial schedule. But I believe the summer break time for both parents doesn't start till after Father's Day. So that should work. And we're gonna start this new schedule on Monday at 8 PM because of the Memorial Day. So Dad gets him all the way through Monday, right? That was your plan?
He'll be with me until Wednesday.
Well, but I'm changing.
Oh, I see, I understand.
Yeah, so I'm just talking about your weekend time would include that Monday. So we're gonna keep that so that the new schedule starts Monday, next Monday, May 26th at 8 PM. Unless you can tell me if there's something conflicts. I said I don't have your guys' holiday vacation schedule memorized.
Your Honor, can my client ask some
Yes.
clarification?
Go ahead.
Thank you.
I'm trying to write while you speak. Can you say that again? That in general, the weekly schedule is,
Okay, so that's, generally Mom's gonna have every Sunday, 8 PM, to eat Thursday drop off at school, school's in session, but this is the last week at school, so that's why, or Wednesday, when, at 8 PM when school's not in session. So for example, next week, Mom will pick up Monday at 8 PM from Dad, and then Dad will pick up Wednesday, the 28th at 8 PM from Mom. And then Mom's gonna pick up again from Dad on Friday at the 30th at 3 PM,
and,
because he's not in school.
and then I keep him that Friday until Wednesday or Thursday, depending on if there's school?
You're gonna keep him from that Friday, yes, because it's your weekend, you're gonna keep him until Wednesday, the 4th of June at 8 PM.
Okay,
Unless a holiday time comes up, like obviously Dad gets Father's Day weekend, that's written in there. And also then whoever gets summer, I don't know who has the first half and who has the second half this year.
in a prior agreement, I planned a trip to Hawaii on leaving the 29th and returning on the 4th.
Okay,
So we had already
So-
made an arrangement that I have that time.
yeah, so why don't we have Dad just keep until Tuesday at the 27th at 8 PM. And then you'll keep him until the 4th.
The morning of the 5th, we fly on the 4th.
Okay, that's fine. So you could drop him off to Dad on Thursday the 5th.
Is the custodial parent receiving, are we still doing the same?
Yeah, just because you're coming back, I don't know what time, he's gonna be tired on the 4th, and I don't know how late you're coming back.
Okay, so deliver him on Thursday the 5th.
Yeah. I'm making a compromise there, so then Dad will have him, let's see, today is your day, right? Under the old schedule, today would be your day.
The 5th would be my day on the whole schedule, oh, I'm
No,
sorry.
I'm talking about today.
Today is my day on the current schedule.
Right, so you're gonna have him today until Friday, when Dad's time for the weekend starts Friday,
Okay, and then I retrieve him on the 25th.
on the 27th. Because that's Memorial Day, that's Dad's Memorial Day weekend.
Right,
So
I'm sorry.
you have him from today until Friday
Yes,
at 3 PM. Dad gets Friday at 3 PM till 8 PM on Tuesday, the 27th. And that way Mom will do that Hawaii trip,
okay.
and Dad will get him back on the 5th. And then that'll be his weekend, so then he has them from June 5th all the way to Sunday, the 8th at 8 PM.
And then I have him, just to make sure, Sunday the 8th until Wednesday night, the 11th.
Yes, and then that weekend, Dad gets him from that way, that'll be his weekend, that's his Father's Day weekend. On the 14th, the 15th are his Father's Day weekend. I think I did that correctly.
Yes,
The third Sunday is Father's Day in June.
yes.
Okay. And then you guys will just keep picking up until your vacation time takes over. And like I said, what did I say? This is an odd year. So Dad's summer vacation begins at 3 PM on the third Friday in June. Okay, so Dad is going to get, based with the schedule, the way it's changing, Dad will get him from the 11th and can start his vacation time then. Vacation would technically start Friday in odd years, right? The Friday before. And then Mom's begins 3 p.m. on the Friday. The Dad's ends 3 weeks later. Okay, so we can plot it out exactly. So Dad gets him on June 11th, and we'll have him all the way till July 4th. Is what I calculated. Is that consistent with what you guys thought?
No, I thought the 11th of July I was normally supposed to pick
Okay.
him up. But in turn for getting extra days to Hawaii, I gave him until the 14th. I was going to pick him up.
Okay, so Dad's gonna have all the way from the 11th of June till the 14th of July? Is that your understanding?
No, not if we're changing it now. That would give him 1, 2, 3, 4. That's like 4.5 weeks now.
Did you mean July 11th to July 14th?
No, June
Summer.
11th.
Okay.
His summer schedule right now is meant to start on Friday, June 20th for summer vacation. The second Friday of June. I'm sorry, the third.
The third Friday. I see where that messed up because June 1st is on a Sunday. Okay. So, but he definitely gets him from the 13th. I guess I see what you're saying. And I'm not trying to mess up what you guys already had an understanding of for the summer. So Dad gets him from the 11th until the 15th of June at 8 p.m. And then Dad will get him on the 18th of June. And then he will keep him until, when did you believe his summer was gonna, with your guys' trade-off of days?
I would pick him up on July 14th with our trip.
Okay. And that works. So Dad has, for his vacation time, we'll have from the 18th of June until the 14th of July.
Could you clarify something?
Yeah.
As it is now, we alternate weekends, and if there's no school on Monday, that parent who has that weekend has that extra day. So
Right.
I'm assuming it would continue.
That's gonna stay the same.
Okay.
That's why you're gonna start the 2 schedule Monday, Memorial Day at 8 p.m. Because Dad's getting that Monday attached to his weekend.
Right,
Judges-
school is over.
Go ahead, please.
School is over on this Friday. But when school starts, if it's a weekend and there's a Monday, then I wouldn't pick him up on Sunday. I'd pick him up.
Pick him up Monday, right.
As I understand it, the June 11th to July 14th, there's like 2 days of custody time there for Mom in the middle somewhere.
Yes, yeah, she
Um,
gets from the June 15th.
For the sake of continuity, again, his dad would like to take the child to be with his family in Ohio. Is it possible to move those 2 days around so we can make it contiguous so we don't have to do the switching around like that?
You don't have to do the switching around. His vacation time, she's right, would start on the 20th of June under the existing order. But changing the custodial order, he gets him for his regular time on the 18th. So he's gonna have 1, 2, 3.5 weeks for his vacation. From the 18th of June all the way to the 14th of July.
So those 2 days in the middle, would it be possible, or wherever they fall, would it be possible to kind of front load those in so that there's no break?
No, that's Mom's time there. So Mom gets him from Sunday, the 15th at 8 p.m. till Wednesday, the 18th at 8 p.m.
Your Honor.
Because he shouldn't have been planning a vacation until the 20th. Yes,
So that's Father's Day weekend, and as it is now, I would normally get him on Monday. Are you saying that we're changing that, and now I get him on Father's Day evening, and he would get him Monday?
yes, that
Okay.
you can have him at 8 p.m. on Sunday.
Okay.
Just to keep it consistent, that you guys remember that the 8 p.m. And the reason for that is that way Dad doesn't have to worry about getting him to school on Mondays. That's gonna be Mom's responsibility.
Okay.
Like I said, the way I'm doing it is so that week 1, is a 2-5 split, and week 2 is a 3-4 split. So dad has 6 days every 2 weeks, and that is 42% of the time. So you guys will still share joint physical custody, it just will not be a 50-50 split. Okay, so that, we have an understanding of what's going to happen, and then July 14th is when you were planning, when did your vacation, I guess you guys, you gave him extra days, right?
Yes.
So your vacation normally would have started on July 11th.
Yes.
Okay. So then you'll have from July 11th to
14th.
August 6th. Sorry, not July, yes, July 14th to August 6th.
Originally it was August 1st.
Is that what you guys are doing? Okay.
Um,
That's what, if that's what your plans are, like I said, I'm not trying to plan the summer.
That-
So
that-
that your vacation ends the 1st of August and you go back to the regular schedule, and then he starts school on August 11th.
Correct, that, the August 2nd is,
That's his week, okay.
Yeah.
So that's dad's weekend, from the 1st to the 3rd, and mom's time, dad's time, and then it's mom's weekend on the 9th and 10th. And then he goes into school on the August 11th. So that gets us all the way through the summer. I think that made sense. Did that make sense? Mr.
I think a few changes ago, I had a little bit of difficulty following, but
Okay, but you're gonna get it all in writing.
yes, that
But the
will
main-
help, yes.
The main thing, you have this weekend, including Memorial Day, and then you're gonna have your vacation time is gonna be, like I said, you're gonna get 3.5 weeks because of the way it falls, is the 18th of June all the way to the 14th of July. So that's a good, and you can start your planning on that now.
Okay, however the order shakes
Sure.
up, my attorney will explain it to me and I'll
Yeah,
understand.
I just want to make sure for the next couple of weeks. This would take a while. Unfortunately, last time it took from May till September to get the findings of fact. It's not going to take us that long this time.
Question, Your Honor, on Monday, Memorial Day, does Ms. get at 8 p.m. on Monday, or was it Tuesday morning?
8 p.m. on Monday.
Okay.
And you guys can always agree to something different that works. If you want to trade time or change the pickup time, something that makes sense. And you've done that before, like when I know when Dad came back late on a evening, Mom said she'd pick him up the next day instead. So he wasn't tired. I saw those thousands of pages of communication. All right, so then child support is appropriate to change. It's also been over 3 years, I think, since the last child support. So my mom's gross monthly income is $8,626. Dad's gross monthly income for child support purposes, I'm imputing what he put on his financial disclosure form on February 13th, 2023, because there's no reason he is not working full-time at this time. So that's $5,403. Base child support from mom to dad is $306. Adjustment factors that apply, the court is going to give a downward adjustment of $250 a month for mom is paying 100% of the extracurriculars. And then I'm gonna give an upward adjustment because, as Mom said, they're having 2 insurances hasn't helped them at all, especially if they're different. The problem is they're both self-employed. They're buying private insurance. And with his tax return, he probably qualifies under CHIP or getting a reduction in that premium. So I just need to know half of that premium for Dad is going to continue to pay is going to be added to her child support. So I can't give you a net. Did you find that, sir?
I can't, I'm having difficulty with the internet connection, but,
Okay, I understand that.
sure.
So it's a county internet connection. So
I'm gonna
basically,
keep trying.
her child support to him is going to be $56 plus 1/2 of that premium. So let's say $130 of the premium is for, then that'll be another $65 added. That new child support will be effective June 1st. Medical insurance, we're going to have Dad do that. If there becomes a reason for them to change that, they should talk about it. But right now, Dad's is more economical, and probably, like I said, he can get subsidies and stuff for his because of his taxable income. Unreimbursed medical, dental, vision, orthodontic, and counseling expenses will continue to be divided equally between the parties pursuant to the 30-30 rule. And what is still owed by dad to mom pursuant to our family wizard is still owed and needs to be paid. As far as taxes and claiming, the order in the decree of custody will continue. Whoever's supposed to have odd or even, I don't know off the top of my head. But I'm not changing that order. Attorney's fees and costs. Under Roe v. Roe, the court cannot grant attorney's fees to a prevailing party in a custody matter. So that limits some of it. And the court is not making a finding that either parent pursued or maintained a defense or a claim in bad faith in this case. There was a lot at stake here. And so the court is not awarding attorney's fees or costs under NRS 18010, I think it's subsection 2B, off the top of my head. But if either party, I will give you the opportunity, if either party disagrees and thinks they're entitled to an award of attorney's fees, they can file a motion pursuant to NRCP 54. With regard to costs, if either party wants to make a claim for costs against the other, they have to comply with NRS 18. That's a little harder in this case because mom prevailed on some issues and dad prevailed on the physical custody. So I don't know off the top of my head whether either would be entitled to costs as a prevailing party, but they can comply with NRS 18 and I will consider that at the appropriate time. As far as preparing the findings of fact and conclusions of law, my initial thought, and subject to council's input, is that each of you could prepare your own proposed and send it to me in Word, and I can figure it out that way, but I want to put a deadline on you. Or we can have one party draft, and you guys can go back and forth with, I don't know which is more efficient.
Your Honor, my request would be, given that my client's not getting an award of attorney's fees and just not out of pocket, it's his family that is, even though I think we've prevailed more than Mr. that defendant prepared the initial draft of the findings. I don't think it should be too difficult because they can get the recording from this one session and basically take what the court has said verbatim and put it into a proposed order. So that would be my request.
Here you can have Firefly or things like that transcribe it for you too.
We'd be delighted. It's no problem. Happy to do it.
When do you think you can have that by? I just want to have, I'm not going to pick on people, it is detailed. So I just want to have an idea in mind that when you're going to get it to Mr. Schonfeld.
Not that I want to be that guy, but we have trials from now until then and other obligations. Would it be okay if the court gave us 30 days? Or is that too much time?
30 days sounds reasonable for as detailed as this is going to be. The problem, the only concern I have is if we don't have in writing the schedule that we went over before that, and maybe we just need an interim order that says, okay, between now and August 11th, this is when each parent has, so they have it in writing for them quickly.
I'll tell you what, since we're doing the detailed one, why
Yes.
why doesn't Mr. Schonfeld do the fast
Before
one?
you interrupted me, that's what I was saying.
Thanks, sorry. I do that from time to time.
You just jumped the gun, sorry. So, Mr. Schonfeld, if you can do that order that just says it's an interim custody schedule between now and August 11th, that way we can have the, I mean, these findings of fact, includes the law, might be 30 to 40 pages. Maybe more when you add the standard language. So, Mr. Leavitt, you're going to give it to us within 30 days, you said, right?
Yes, sure.
So that puts us at, let's just call it, you're going to get it to Mr. Schonfeld by no later than June 23rd.
Yes, Your Honor, I'll
Because the 21st is a Saturday, so
I will
give it to him on
endeavor
Monday.
to do it.
All right, and then Mr. Schonfeld, you can review that within 2 weeks. And
That's fine.
that. But even if you both sign it, I know myself from trials, send me both the signed version in PDF and the Word version.
Happy
Because
to.
Possible I may reword some things or clean up some language
Happy to.
when it translates from what I said to actual paper. Sometimes it doesn't translate either. All right, so Mr. Leavitt, any other clarifications or questions other than we talked about the schedule?
No, I don't think so. What?
Your Honor,
What?
I know my client's gonna have some questions.
Just hold on
Go
2
ahead.
seconds. Let's see if Mr.
the question, Your Honor, is if she has sole decisions on medical, what happens if, like, in his care, the child is sick and there's an emergency situation?
That's included in the joint custody, that yes, both parents have the right to get emergency care, and they just need to notify it. So that part of the decree is incorporated under the joint custody, but that's a good question, yes, and you guys just need to keep each other informed. I expect you to take him to the urgent care if you need to,
Regular counsel appointments here.
preferably one that's under the insurance though.
So, as I understand your question, you want to establish the therapy sessions like on a go-forward basis, like so you know?
Just want, yeah, in writing, like very clear, impossible to.
Okay, let me try to short circuit this. So is it possible, like, to schedule the therapy appointments like in advance so that he can kind of plan and know where things are at? Is that
Well,
possible?
he can definitely schedule his once a month. I'm saying follow Dr. Smith's recommendations, was that each parent bring him once a month. Now, Dad has Friday, so, and that seemed to be where they were doing, so Dad may be able to make that Friday pretty easy, and then just put it on our Family Wizard. I made my appointments for the counseling, boom, but I mean, the summertime, you guys might not get much in there until you come back, or you might get one in June, but not July and August, or not July, should be able to in August. So yes, Dad can make that once a month, and Mom can make once a month, and they both upload it on our Family Wizard. I want Dad to have the opportunity to take him, but he hasn't done it consistently,
Right.
and he hasn't had enough. And if Dr. Smith recommends to go less, then you guys follow his recommendation.
Right.
How far does the order to follow Dr. Smith's recommendations carry? Like, can you modify the way in which she and I are supposed to communicate?
Okay, let me try to short circuit. So as I understand your question, what you're asking is Dr. Smith empowered to kind of,
How far does it go?
how far?
Like, if he says you guys can come in and have a joint session, can you guys now email each other?
So does Dr. Smith, is he empowered to kind of modify
The orders?
the communication protocol or the amount of visits or whatever?
Not the court orders, but he definitely is empowered to change what, as, I'm not a mental health professional, and neither are these parties. So we have to follow the
Sure.
advice of that. So if Dr. Smith says, I don't need to see him as often, once a month is fine, and each parent can alternate.
That's what we wanted to
wonderful.
know. So,
You know, we're not taking him to more counseling than he needs.
great, that's exactly what
But
I
I
think
want
the
the parents
question
to listen to the
was.
professionals.
So we will defer to Dr. Smith as to
When it comes
frequency
down,
and whatever.
Right, but he did testify, right now, he still thought twice a month, with each parent bringing once a month was,
Like, have a joint
Appropriate.
session, or he can do that.
I don't know that would, the question, and I'm gonna see if I can try to phrase it in a way that I think I understand it. So the question I think you're asking is, what if Dr. Smith wants to see the parents together? Is that something that the court is inclined to do? Should we defer to Dr. Smith on that? Is that what you want?
I'd rather follow the orders, but Dr. Smith is wanting to see us together and communicate outside of OFW, which is my concern.
So the representation, Your Honor, is that Dr. Smith has wanted to see the parents together and has, I cannot confirm or deny, but wants the parties to communicate outside of OFW. So I don't know if that's true.
well, yeah, I don't want them communicating outside of OFW because we see the problem, just from an evidentiary perspective, the problem it makes. And text messages are so much easier to spoof, modify, change. Our Family Wizard is safer
Sure.
and easier for these people, and they should use the tools they have.
Historically.
So,
teachers have made so many-
If Dr. Smith wants to meet with both of you together, to talk about, and get you both on the same page regarding something around mental health, I think you should do that. I know that both of them have avoided being together at a lot of things for good reasons,
Yeah,
But-
that makes sense.
but if there, and the two of you are going to talk with Dr. Smith about it, I think you can do that.
Your Honor, we do have some clarifications. when
Yes,
they're-
I'm
when they're
gonna
done.
give you your chance.
Yeah, so whose responsibility is it? Like, as clearly as we can make it.
As I understand the question, he wants to know with regard to homework assignments, apparently the teacher makes certain assignments due on certain days. How is the court inclined to require that? Should we follow the teacher's recommendation? So if the assignment is due on the particular set date, or is that your question? I want to make sure I
I
understand.
granted mom's request to change what they wanted on the school days. So he only has the Thursday. That's what she requested, to be able to do that. And I granted that, but kept it a shared custody. So, and he's gonna have a new school teacher come 5th grade, so it may be a totally different homework protocol with the new teacher.
Sure, that makes sense.
But he's responsible for he's responsible for what is due on Friday, because he's gonna have to take it. Friday is the
Fine.
only day he's
Yep.
responsible for taking him to school.
Perfect, got it.
So once a week, he has to take him to school, and that's a fair division of the transportation issue too, as well as making sure he gets to school on time.
We have the ability to get that tax credit back. At what point can we get the tax credit back? Because the order was mom needed to do it, mom wants her to do it if I don't file.
Okay, so I think I understand. So the question is, with regard to the tax credit for the minor child,
Yes.
I think the representation is that historically mom was able to get that, and if she hasn't filed, would it be possible for dad to get it so that he could claim the child if mom is going to choose not to file taxes? Did I say it right?
Yeah.
Okay, let me go back to the decree, because I do not remember 4 years ago what it said, but typically with them having shared custody, I would have, and one child, I would have, where it is, on page 30 of the custody decree. Plaintiff will have the tax deduction for dependent for tax year 2020 and all even years. Defendant will have the deduction for all odd number of years. However, the court knows that defendant does not have any taxable income for 2021 on his tax returns for which the deduction would be meaningful. He should let the plaintiff use the deduction rather than giving extra money to the government that doesn't have to be given. That's basically.
So I guess what his question is flip that. In theory, if she's not gonna file and he does, and he can benefit from it, could he have the tax deduction that year if it falls on an even year?
You remember my
Even years is
client's,
for mom.
she's filing her returns, so.
Yeah,
this
she
isn't
owes
an issue.
taxes, so she's gotta file her returns to do that. But what I'm saying is, if he continues, if he gets a full-time job and he's making $60,000 a year, he's gonna need that tax deduction.
That's the point.
In odd years, and he should have that. But if he's not, until he's making an income where that it would benefit him, he should let mom claim it, and that's what I ordered.
You get the tax credit.
You know, so for 2025, we're already at the end of May. I don't know how much she's gonna have for taxable income for 2025.
Yeah, and what I'm asking is, again, if he has that $60,000 a year job and mom is not gonna file a return that year, can dad have it in an even year, even though,
I understand the question, and the answer would be, yes, I would expect it. If she can't benefit from it, from either she has no taxable income or anything, then she should let him know, and he can claim in that
that
even
was the
year.
request.
I mean, it's fair for both parties, that if he can't benefit, mom gets to use it,
It's gone.
Okay.
and vice versa.
Child support that she owes to husband.
All right. Mr. Schonfeld, you had some clarification?
Yes, Your Honor, the first one was,
that's still
you had an offset for child support in the amount of $250, and in exchange, my client pays 100% of the extracurricular.
Yes,
That doesn't address gear, equipment, and things of that nature, which can get very expensive.
but that gives her $500 a month, because.
It's $250 a month.
I know,
Well,
it's
$250
a
each.
half, right, so it gives her $500 a month, and she said she spends, I looked at her financial disclosure from Marcia, she said $490 on extracurricular and sports. So that's what I used, I just rounded it to the 500, so she is going to have to provide the gear, unless they make an agreement to it, and it depends, because certain sports are very expensive, soccer a little bit, but not as expensive as hockey, if you decide to do hockey, or even football with pads and helmets and stuff. Can
I'll
be
sign him up for
expensive.
horse jumping.
Yeah, then don't talk about horse. A horse costs a lot of money to board and stuff here. So, but the normal stuff she's doing, let's put it this way, she can always come back on a motion if she is spending more than $6,000 a year on it, and I can adjust it. I have that ability to adjust going forward, any thing. but I'm just trying to reduce the points of contention between these parties in a fair way to both of them.
Sure. With regard to the music that, the extracurricular for music that dad has been doing with the child, I presume the court is inclined to have him continue in that regard?
Yes, and it doesn't, from his testimony, I took it that it doesn't cost anything. There's not a cost to
My
it.
payment comes out of my salary.
Comes out of his paycheck from the, what was the name of the place?
Rare Spark Plus.
Rare Spark Music.
If he wants him to do music, he can do it on his custodial time, and then it's his expense and his choice on that.
Your Honor, one of the other issues we wanted to ask is if we can discontinue the weekly communications, because Mr. participate in them and use the OFW on an as-needed basis. So the OFW would be the form
Right,
of
they're probably gonna
communication,
need to
but
communicate more in terms of, especially her, giving him the information. If she's the one who's the holder of the information, like on if it's Tuesday again, next year that the stuff comes home that he needs to know about, she's gonna have to upload it. So I can eliminate that communication protocol.
just the weekly
Just the weekly
communication on OFW.
Yeah, on what, okay, so we'll eliminate the weekly part of it, but keep in there the subjects that they shouldn't talk about, and that's consistent with the mutual behavior order.
Yes.
All right,
And
that
then
makes sense. Yeah, understand what
another
you
one
want.
is oftentimes my client will get an email, for example, if one of the medical providers sends her an email with records, they're not allowed to email each other. Can she forward emails without including any additional communication, just forwarding? Or for example, there's an extracurricular activity and she gets an email, can she forward it?
I guess that works, but it would be better if she downloaded the attachments and then put them in our Family Wizard.
Yeah.
That way it's all in one place.
Sometimes the emails are pages long and they have links in them, which I can't transfer the link.
Right, if it's links that big of a link, then you forward the email to him
So I can,
and maybe put it in our Family Wizard. Hey, I forwarded you an email that has links you should look at
Okay.
from, whoever.
Just make sure that it's the email address I have on file with the court.
And that
Yeah,
would
I
work
just want
both
to
ways.
confirm that it's the correct email address, the personal one at,
That's a very good question. Put it on the record exactly what email. See, apparently has many email addresses.
Just whichever one.
Which one would he like to use? The Doug
When do you want
Rothman
them
one
to
go?
at Gmail?
The one that's on file with the court. We'll make it.
Help me remember that. What do we have there,
It's-
Joey?
At yahoo.com.
Yahoo, I said Gmail, sorry.
Just so the record's clear, and is that what we have? At Yahoo. Okay. We have that? I don't have. Oh, I'm looking at the child. I wonder if there's no email. Yes. All right. So it's just personal with no number at yahoo.com, right?
Yes, Judge.
That's what
Your
visual
Honor.
person had to see it. Any other
One more,
questions?
in addition to, so there's an IRS tax credit for the child, but then there's also head of household, and that's based upon who has more physical custodial time. So my client would be using that on her tax return. That's not
And
something that would get
That's gonna be
alternated.
between her and the IRS and
We're
That's
just
fine.
letting Mr. be on notice, because if they both do, it's gonna become a problem.
right, because of the time frame, she would be able to claim head of household each year, but not claim him as a dependent.
Yes.
That's what he's saying, so. I'm not interfering, whatever the tax
I was
code
gonna
says.
say, I'm not a tax attorney and I'm not gonna opine, I don't know.
Okay,
I know a guy.
Oh, and there's some other, in addition to the therapy expenses, there's other expenses, medical related, that have not been reimbursed, so I advise my client that she should re-upload those as well.
right, and make sure, and then both of them, and I think I explained it in a prior order, because I remember reading it last night, is that they upload the expenses and the other parent has 30 days to either object and put what their objection is, or pay it.
So he has Zelled her several times. We're gonna have to do a, Zell thing to see what has been paid and what hasn't, because he has made some payments.
Right, because I noticed I think she admitted on our Family Wizard that had some that was owed, but I didn't know if it was like up to date. Might have been as of the discovery.
Yeah, we're gonna have to map it out and figure out what's been
Yes.
paid and what hasn't.
I do know he owes her for counseling, but, and going forward, they're gonna have to both upload. And it may work out the same, and they could say they wash each other if he's doing what he's supposed to do and do once a month until Dr. Smith changes that. And they're both taking the same amount of time, but that hasn't happened in 24 or yet in 25.
Or what about school field trips? Expenses for those? It should be 50/50, obviously it's in.
Yeah, you guys have been doing a lot of things that are 50/50 in there, so I'm not gonna change what you've been doing. So you've been reimbursing each other on who does school, because I've seen the communications, school supplies or something like that. You've been doing some of that.
We have not.
Not.
He reimbursed one field trip, the $15 one. He did not reimburse the $450 Disney one. School supplies, we're supposed to split, we just don't. It just never works out that way.
I don't mean to
In a
dredge.
case like this, it's probably better if we minimize the reimbursements, but something as big like a Disneyland trip or next year, some schools on 5th grade go to SeaWorld
Did you
trip. Those big expenses,
notification?
I'm sorry, I was,
big expenses for your son at school. I mean, it doesn't make sense to me, for you guys to worry about $15 or $10, whatever. But the big expenses like the Disneyland trip or next year if he goes on a SeaWorld trip, those big expenses should be shared.
I
So
understand.
let's put a materiality of $20. So if it's a bigger expense than $20, upload it and share that, no matter who pays it, because it may be due on a Friday and you may pay it. And you can upload that and it can be offset against what you owe her. So I'm trying to reduce the number of bookkeeping issues you guys have.
I understand. I would request that over the past 2 years, I've paid for nearly 100% of school supplies and have avoided uploading a receipt to avoid conflict.
Okay,
Can I seek reimbursement for those now, or is that past?
As I understand it, what he's looking for is an offset of what he's paid for school supplies against other offsets that she has for him.
I'm not gonna allow, if they're over 30 days old, I'm not gonna allow either of you to do it, because again, I'm trying to reduce, it's just about reducing points of
Yeah, but
conflict.
Your Honor, pretty much everything is over 30 days old.
Everything's a what?
Pretty much everything's over 30
She's
days
already
old.
uploaded them and your client disregarded or
Well,
ignored them.
Right, she uploaded them. If he didn't upload them within 30 days, so they're already in our family wizard. And some of it he's ignored, and some of them he's declined, and some of them he's paid, he said, he's owed her money, so. Again, I'm trying to reduce the bookkeeping. It's like clothes, you guys have shared custody, he should have his own clothes in each house. But he may have a major purchase, like a ski suit, that might cost a lot.
Your Honor, some more clarification. You said for school activity, each parent on their time can enroll without the other parent's consent.
Yes,
We want to make it clear that, for example, Brave Eagles, Feathered Eagles, the school counseling stuff, my client has the authority to enroll. And then the other one is field trips. For example, she shouldn't have to come to court to sign the Disney or the SeaWorld trip that may come up next year.
No problem.
and I get what you're saying, but I did say that if it's a field trip on Thursday or Friday, those are his custodial days. So she may need to if there's a dispute between them. I don't know. I don't know. I never heard from Mr. what was his objection about the Disneyland trip. So,
Your
Your Honor, sorry.
Go ahead.
field trips are generally always on a Thursday or Friday. So I would
So-
have no say.
Mr. Do you have objections to your son going on field trips?
No, the Disneyland trip was a specific objection due to the travel time and the safety issue with the wildfires.
Okay.
Going forward, I am willing to agree to all school-sanctioned field trips, at least for the coming year, unless either party presents an objection. But I would like that to go for, each parent.
Yeah, okay, well, let's put it in there that you're going to be able to attend his school field trips unless there's a very specific objection to it, that you both, either one of you could sign the consent forms and put them in, so they get in timely and he can go.
Can we have more clarity on an objection? Because as the court has seen, there are objections with no basis for the objection.
And that's the hard part, is for me to predict what may come up. I can't predict every situation, but he put on record, and you can put it in the order, that he and said that he consents to him going to all the school sanctioned trips. I guess we can say,
Can we say, and if a party objects, they have to seek court relief?
that's a good idea, that the objecting party can seek court relief, and it can be on an ex parte basis. But you gotta serve the other side.
Judge, as far as the question was posed to me, how do the parties want to communicate with the child about the new schedule change? How are we going to help him understand how this is gonna go?
I think that I would keep it generic and just say, we're gonna try a new schedule. We're trying a new schedule.
Are the parents doing that together, or is that one parent? How are we going to do that?
Well, I don't know that these parents could do that together, but,
Your Honor,
go ahead.
when we've had an order in the past, I've told that we made an agreement. And of course, you made the agreement for us, but I presented it as unified. We made this decision together.
And that may be the best thing to say, just because he doesn't need to know about court at 9 and stuff like that. I mean, but he's older and more aware of things. So if they both say to him, we've agreed to try a new schedule, see what it works out like. I don't know. I mean, I'm glad he's seeing Dr. Smith, because obviously he doesn't want 2 homes, he wants 1 home. He said that less, but in 23, that was really strong thoughts. And I can't make you guys be together. That might not work out very well.
Sure.
So you can't be together in 1 home. And I'm not gonna cut either one of you out of his life. You both have a good relationship with him, and he loves both of you and wants time with both of you. So, like I said, I'm just trying to reduce some of the stress. I mean, because the studies do show that parental conflict is stressful to children, especially when they don't have the maturity to understand the gray areas of it, and they also don't have the control over it. So they just stress about it. Anything else?
I think that's it for now, Your Honor.
Please take your witness copies with you of the exhibits. If you haven't already, take them with you.
When it comes up, you let me know.
I am fine with
The order
this
when it comes
launch
up.
whenever you want.
I can't foresee everything.
The other thing might seem small. I have 1 video game account to share, like his own. I've made him his own, so he can play with his friends on the same account. I don't know if he can roll on. I made him his own account for him to decide what he wants to do with it. And I just want to know he can utilize it at his house if he wants to. To play
Have you
his
shared
friends.
with him the
Yes,
credentials?
he has all of the information.
I mean, that makes sense for your son.
My concern is that develops into a playing online, trying to play with dad at one house, trying to play. I'm totally fine with mom while he's at my house, but my concern is that would become an issue.
It's just his friends who he shares. He plays games with his. I want him to be able to connect with the same friends that he does at our house, that he does. They play Minecraft.
And these guys do progress on these games and stuff.
Yes,
They
and
don't
they
lose
save
their
it.
progress and all that
Yes.
kind of stuff.
Yes.
I mean, yes, it's much different than when some of us were young. We had Ataris, but not before the internet and things could travel and go internet gaming. Sorry, I'm dating myself with the Atari there.
I had an Atari, Judge.
I'm sure you had more than one.
I don't want video games. We have our time limits while he's at my house. But I would like it if he could play with his friends, on 1 account. Is what I'm asking.
Do you understand? I'm looking at your face, you might understand that. I've already made a ruling that each of you can decide the limits of his electronics and internet stuff in your own houses. So she says she doesn't want you playing games with him while in her house. but she wants him to be able to use the account to play with his friends in both homes. And I don't think you have an objection to that. I saw some communications about that between both of you.
I think this will help me understand. The FaceTime schedule, does it also function as prohibition on him contacting the other parent, or on contacting the non-custodial parent? For example, because my concern, not my concern, but if my house and says, I want to FaceTime mom and show her this thing, or yeah, I'm going to play a game and I want to play with mama. Like, is he prohibited from contacting her? Because I would be okay with it. That's
No, and that's, I think what she just said was, she's okay with him calling, doing FaceTime when he wants to, outside of the schedule. The schedule is the minimum. So
Okay.
as he gets older, he's also, at some point in time, you guys are gonna have to make the hard decision of whether he gets a cell phone. My hope for your son is that he doesn't have to carry 2 cell phones. That's my hope for your son. But I also believe that both parents have a right to make parenting decisions that are in their own home. But if you guys can agree when that happens and what the safeties are, because you both know that there's a lot of dangers with these smartphones and internet and people pretending to be even play. I don't understand why a 30-year-old would want to play Minecraft with kids, but I pretend they're a kid, but they do. And they're predators out there. So I want you guys to hopefully agree, if you can, on safety protocols for your son when you get to that point that he has a cell phone for regular usage. But then when he gets his own, my point was going there, is that he's going to contact either one of you, and it may not be as many phone calls as you're doing now, maybe more text, because these kids text more than they call.
In order, just so Mr. Clear understanding, although my client is willing to have call his dad if that's what to do outside of the FaceTime protocol, she is not willing to allow play video games with in her household or in her care.
Right, I think she's made that clear.
Okay.
And that's a parenting decision I'm gonna allow her to make and have it allowed. And Dad, you have the right to make limits on what he does and in your house as well with electronics and stuff. And reasonable people can disagree about how much time for a given age it is. There's recommendations from like the American Pediatric Association, things like that. But reasonable people can disagree on that range. So I want her to say her limits on computer or electronic time is an hour a day or whatever, that's fine. If you want him to have more, that's fine too in your house. So she made it clear on that, but both of you have also said on the record that he can call either one of you outside those parameters. And he, like you said, Dad said maybe he wants to call and say, hey, look at this, because they use the video calling, and that's perfectly fine. I'm just trying to reduce points of, like, if you two agree on something, I'm not gonna second guess you. There's not a lot of things you guys agreed on in the last 4 years, or more, but at least 4 years that we're looking at.
Your Honor, sorry, this sounds petty. I just want to make it clear that if we come to an agreement on something that goes against the order, like a FaceTime or a schedule change, or hey, you can sign him up for this thing, that we're okay if we both agree. Like, I've had problems where he says, no, it's not in order. But we can agree on something.
Yes, you two are parents. You have the right to make agreements that don't. The court orders are there for things you don't agree on. If you both agree, you're gonna send him to Korea for a week, I'm not gonna tell you you can't do that. You guys can do that, but if you wanna switch weekends, and that makes the most sense, do that.
What about North Korea?
Like I said, three,
the do not travel.
if they agree, they can send him to North Korea, Mr. Leavitt.
Sorry.
If they don't agree, then I've litigated issues more about Mexico, and then I make them follow the State Department recommendations. And I think North Korea is on the do not go list. But you're making the extreme example. But if they agree to flip-flop a weekend, you guys can do that. If you agree to move to a different day on the phone call, do that. If you guys agree that you don't need a phone call today because you both saw him at soccer practice, okay, you don't need to do that then. What you guys agree on, but for both of your purposes, put it in our family wizard in writing Okay, this is what we're gonna do, you're gonna get this weekend, and I think you guys have tried to do that. I'm not saying you haven't, but keep doing that. So the better you guys are clear on that, that, hey, we're flipping these weekends, then the more, less problems you guys have in the future on those. Anything else? Either side, all right.
Thank you,
Please
Your
take
Honor.
your binders, your extra binders with you and recycle, thank you.
Thank you, Judge.
Thank you.
Yeah, they're right there. What's up?